Hi, this is Professor McKay. This is the lecture for week 4, and these slides are posted under week 4 in the lecture slides tab, so you can pull those up as well and follow along at your own speed. This week's topic is the regulatory environment. We'll do a quick review from last week, and then we'll talk about building codes, Americans with Disabilities Act, and differing site conditions. So do these questions at your own speed. Who owns the design? What should you negotiate for in a design agreement when representing an owner? And a VE proposal question. Last two questions. Who is responsible for construction means and methods? And does the project architect have a duty to inspect all the contractor's work? We'll go through the answer to those questions right now. Remember that the ownership of the design is in the designer, unless the contract says otherwise. Number 2, when you negotiate for a design agreement on behalf of an owner, you need to include a license to use the design for all purposes related to the project. The VE proposal, or value engineering, that implicates the unlicensed design issue that we talked about last week. So contractor needs to make sure they get a sign-off by the designer of record. Construction means and methods, that's the responsibility of the contractor. Number 5, the project architect's inspection duties are whatever it says in the contract, based on that independent school district decision that we read last week. Alright, moving on to today's material. Building codes. Minnesota Chapter 326B is where our state building code is codified. And the most important thing to remember, I think, about building codes is that the purpose behind them is to protect public safety, just like we saw with licensing laws. And one of the issues about enforcement is uniformity. Some municipalities, county level, also have sometimes their own building code regulations, and the question is, how do those get enforced when there's a conflict between local regulations and the state code? So we'll look at that. We'll also talk a little bit about criminal liability for code violations. This map shows how the building code, the state code, is enforced throughout the state of Minnesota. The areas in purple, which are kind of mostly around the metro area and a little bit in the south, are the counties where the state building code is administered throughout the county. And the white areas are where it's the responsibility of townships and cities to enforce the code. Though there can be variation in how the code is enforced, particularly in the outstate areas. And that's a problem for builders. The first case that you read that has to do with building code, the City of Morris versus Sachs Investments, is really focusing on this conflict issue. Make sure you go ahead and read that case, but the synopsis of it is basically the rental housing code in the City of Morris had some provisions that conflicted with the state building code. And the question is, which code takes precedence? And the main thing to take away is, if it is an area that is being regulated by the state, then the state code will take precedence over any local regulations. Even if the local regulations are more stringent, it's not the most stringent that governs, it's whether or not the state building code regulates the specific area. If so, the state code will govern. And the goal of uniformity is important for builders to know how they're supposed to build in the state of Minnesota, regardless of what district they're in. If it's an issue that's not within the building code, then a city or county can regulate it as it sees fit. State v. Arkell, there's two cases here, a Court of Appeals case and the Minnesota Supreme Court case on the issue of whether criminal penalties, including jail time, is an appropriate sanction for violations of the state building code. This picture shows the development, townhome development in southern Minnesota that was at issue in this case. Mr. Arkell was a corporate officer of a construction company. He was sentenced in the trial court, I believe, to about 90 days of jail time, 10 days suspended, and a fine on top of that for persistent failures to rectify violations of the state building code. And the Court of Appeals, if you read that case first, did believe that jail time is an appropriate penalty for a responsible corporate officer. They looked at the public welfare nature of the building code that we've already talked about. They looked at Arkell's power to control whether or not these persistent leaks that were occurring and flooding that was occurring at this townhome development could be fixed. And they also considered the fact that the contractor's duty of care is non-delegable. There were 7 letters written by the city to Arkell and plenty of evidence that he failed to take action to correct the problem. So Minnesota Court of Appeals affirmed. On further appeal to the Supreme Court, it was reversed. And the Supreme Court did not want to characterize this as a public welfare offense that would warrant the imposition of criminal penalties. That quote down at the bottom, classifying the building code as a public welfare statute for criminal prosecutions would set a dangerous precedent. The Supreme Court really didn't want to open the door to criminal prosecutions of negligent builders. I think the underlying theme is that this is an issue that needs to be addressed civilly, perhaps through license revocations, things like that. But the Supreme Court did not want a bunch of criminal prosecutions of contractors when there's plenty of other more criminal type activity here. It's a kind of a questionable decision because the building code does definitely say that it's a public welfare statute, so that reasoning doesn't really hold water in my opinion. But one of the discussion questions this week asks you to weigh in on that question.